Constitutional law should be boring, but if you turn on the news, you will soon realize that it is all everyone is talking about. From turmoil in the USA to debates about human rights in the UK, public law and the role of the courts is the topic to talk about. This podcast presents the key aspects of English public law one needs to know for the Solicitor's Qualifying Examination, the SQE. Stick around if you are a law student or interested in the Constitution more broadly. There is something in here for everyone. Let's get going. The British Constitution is often characterised by a series of well-established classifications. It is unwritten in that its core principles are not codified into a single supreme legal document. It is flexible as it can be amended by a simple act of Parliament. It is monarchical with a hereditary head of state, and it operates as a parliamentary system where the executive is drawn from and accountable to the legislature. In its formal structure, the United Kingdom is also a unitary state with ultimate legal authority concentrated in the central parliament at Westminster. These foundational descriptions, while accurate, provide an increasingly incomplete picture of a constitutional order under immense strain. The traditional unitary model has been significantly modified by the devolution of substantial powers to legislatures in Scotland, Wales, and Northern Ireland, leading many scholars to describe the UK as a quasi-federal state. This delicate, often ambiguous settlement is now being tested as never before. The period since the 2016 referendum on European Union membership has unleashed profound political and legal shocks, forcing a re-evaluation of the Constitution's core tenets. This podcast provides a comprehensive analysis of the current state of the British Constitution, assessing the accuracy of foundational understandings and providing critical updates on recent developments. It will demonstrate that the Constitution is not a static set of principles, but a dynamic system reacting to the pressures of EU withdrawal, heightened tensions within the domestic union, and a recalibration of the relationships between the state's key institutions. The podcast has been prepared by Dr. Yannis. Have a look around Dr. Yannis' YouTube channel for more podcasts to help you prepare for the SQE. The foundational principles of parliamentary sovereignty, the rule of law, and the separation of powers remain central to any understanding of the UK Constitution. However, recent years have seen each of these principles subjected to significant stress, leading to a reassertion of a more political, executive-centric vision of the Constitution over a legal, judicially mediated one. The doctrine of parliamentary sovereignty, famously articulated by A.V. Dicey as the very keystone of the law of the Constitution, holds that the UK Parliament has the absolute legal authority to make or unmake any law whatsoever. Its historical origins are traced to the Glorious Revolution of 1688 and the subsequent Bill of Rights of 1689, which established the supremacy of Parliament over the monarch in matters of legislation and taxation. For decades, the most significant challenge to this doctrine was the UK's membership of the European Union, which required the UK courts to give supremacy to EU law, a development that Sir William Wade characterised in the wake of the Factortame litigation as nothing short of a constitutional revolution.
The UK's withdrawal from the EU has rendered this specific debate moot, but its aftermath has triggered the most significant legislative reassertion of sovereignty in modern history, the retained EU law Revocation and Reform Act 2023, a Rule Act. This act was designed to end the special status of retained EU law, a category of domestic law created by the European Union Withdrawal Act 2018, to ensure legal continuity by preserving EU-derived laws in the UK statute book after Brexit. The Rule Act's effects are profound. As of 1 January 2024, the entire body of remaining EU law was renamed Assimilated Law, signifying its full absorption into the domestic legal order and subjection to the ordinary principles of parliamentary sovereignty. More fundamentally, the Act explicitly revoked the principle of the supremacy of EU law and abolished the general principles of EU law as an aid to interpreting the UK statute book. To manage the vast quantity of this legislation, over 6,700 individual pieces were identified on the government's dashboard. The Act grants ministers extensive delegated powers to revoke, restate or replace this law, largely until a deadline of June 2026. This legislative project represents the ultimate triumph of the Diceian model of sovereignty, as Parliament has legally reclaimed the authority previously shared with EU institutions. However, the method chosen to achieve this has created a constitutional paradox. The political driver for Brexit was the concept of taking back control, a clear expression of a desire to restore parliamentary sovereignty. The Orul Act is the legal instrument for this restoration, yet the sheer volume of law to be processed made a line-by-line replacement through primary legislation politically and practically unfeasible. Consequently, the government has relied heavily on broad delegated powers, often referred to as Henry VIII clauses, to give ministers the flexibility to amend this body of law with significantly less parliamentary scrutiny than is afforded to primary bills. This has led to a situation where the principle of parliamentary sovereignty has been emphatically reasserted at the institutional level, while the practical day-to-day power to reshape vast areas of UK law has been concentrated within the executive. The rule of law, a principle with a lineage stretching back to Magna Carta, posits that the state should be governed by law and not by the arbitrary exercise of power. Dicey's formulation identified three core elements: the absence of arbitrary power, equality before the law, and the derivation of rights from the ordinary law of the land. Modern jurisprudence distinguishes between formal conceptions, which focus on the procedural characteristics of law, that it be clear, public, and prospective, and substantive conceptions, which argue that the rule of law must also encompass the protection of fundamental human rights.
A significant recent development that tests the boundaries of this principle is the increasing legislative use of ouster clauses, which are statutory provisions designed to limit or exclude the jurisdiction of the courts. The most prominent example is found in the Judicial Review and Courts Act 2022. This act contains a clause specifically designed to reverse the effect of the Supreme Court's 2011 decision in R. Carte versus the Upper Tribunal. The Carte decision had established a narrow but important jurisdiction for the High Court to judicially review a decision by the Upper Tribunal to refuse permission to appeal a case from the first-tier tribunal. The 2022 Act now legislatively removes this avenue of review in most cases. This move was justified by the government as a measure to increase judicial efficiency, reduce unnecessary litigation, and respect the finality of decisions made by specialist tribunals. However, it has been heavily criticised by those who view it as a significant restriction on access to justice and a direct challenge to the court's constitutional role in upholding the rule of law. The abolition of Carte judicial reviews is more than a procedural tweak. It brings the long-standing theoretical tension between parliamentary sovereignty and the rule of law into sharp practical focus. The Supreme Court in Carte had carved out a review jurisdiction based on its understanding of what the rule of law required. The executive, viewing this as an impediment, used its parliamentary majority to pass an act that explicitly ousts that jurisdiction. This sequence demonstrates Parliament, at the behest of the executive, using its ultimate sovereign authority to override a judicial interpretation of a fundamental constitutional principle. It signals a clear preference for a political constitution where Parliament's legislative will is final over a more legal constitution where courts have an inherent and protected role in ensuring legal accountability. The doctrine of the separation of powers, most famously articulated by Montesquieu, advocates for the division of state functions, legislative, executive, and judicial, among separate and independent bodies to prevent the concentration of power and protect liberty. The UK system has never adhered to a strict version of this doctrine, instead operating with what is more accurately described as a fusion of powers, most notably seen in the executive, the Prime Minister and Cabinet, being drawn from and sitting within the legislature, Parliament. Despite this institutional overlap, the judiciary has long insisted on the importance of a functional separation, particularly between the courts and the political branches of government. The most significant recent test of this principle arose from the 2019 prorogation of Parliament. In the landmark case of R. Miller versus the Prime Minister and Cherry versus Advocate General for Scotland, the Supreme Court ruled unanimously that the Prime Minister's advice to the Queen to prorogue Parliament for 5 weeks was unlawful. The Court's reasoning was not based on the political motives for the prorogation, but on its constitutional effect. It held that the suspension of Parliament was exceptional in its length and timing, and that it had the effect of frustrating or preventing, without reasonable justification, the ability of Parliament to carry out its core constitutional functions of legislating and holding the executive to account. This judgment was a high watermark for the judiciary, establishing for the first time that the exercise of this royal prerogative power was not beyond the law, and was limited by the fundamental principles of parliamentary sovereignty and democratic accountability.
The military judgment can be seen as a powerful judicial defense of the separation of powers, not by enforcing a rigid demarcation, but by protecting the essential function of the legislature from an overreach by the executive. However, this judicial intervention was viewed by the executive as an unwelcome intrusion into the political arena. The government's subsequent actions, particularly the initiation of a review into judicial review that led directly to the Judicial Review and Courts Act 2022, can be interpreted as a direct reaction. By legislating to create new remedies that give the executive more control over the consequences of a successful legal challenge, discussed later in the podcast, the government sought to reassert its authority. This sequence of events, a powerful judicial check on executive power followed by a legislative effort to blunt the tools of judicial review, demonstrates the dynamic and often adversarial nature of the separation of powers in the UK, where each branch continually seeks to define and defend the limits of its own constitutional territory. The institutional framework of the UK is undergoing significant change. Long-stalled reforms to the House of Lords have gained new momentum, while the Devolution settlement that has defined the UK's territorial constitution for a quarter century is facing its most profound challenges yet, threatening the stability of the Union itself. The House of Lords, the UK's second chamber, is a unique legislative body, composed almost entirely of appointed members. Its modern composition was largely shaped by the House of Lords Act 1999, which removed the right of most hereditary peers to sit and vote in the chamber. However, as a result of a political compromise to ensure the bill's passage, 92 accepted hereditary peers were allowed to remain, a situation intended to be temporary pending further reform. For over 2 decades, subsequent efforts to move to a largely or wholly elected second chamber have foundered in the face of political disagreement. Following the 2024 general election, the new Labour government has made completing this unfinished business a priority. It introduced the House of Lords Hereditary Peers Bill 2024-25, which, as introduced, aimed to remove the remaining hereditary peers by repealing Section 2 of the 1999 Act. As of late summer 2025, however, the bill was amended at Lords Committed stage so that existing hereditary peers would remain in place, with changes only applying to future vacancies. The bill was scheduled for Commons consideration in September 2025. The government has explicitly framed this as an immediate modernisation and a first step in a more comprehensive, long-term reform agenda. There's broader ambition, heavily influenced by the 2022 report from the Commission on the UK's Future. The Brown Commission includes proposals to eventually replace the Lords with an elected Assembly of the Nations and Regions, and to introduce measures such as a mandatory retirement age and a statutory participation requirement.
The decision to pursue the removal of hereditary peers as a standalone initial measure reflects a strategic lesson learned from decades of failed comprehensive reforms. History has repeatedly shown that ambitious, single-stage Big Bang reforms of the Lords are highly susceptible to being blocked by political opponents who can exploit disagreements over the complex details of a new system. By disaggregating the problem, the government has isolated the most anachronistic and constitutionally weakest element of the Chamber's current composition. The principle of inherited legislative office is far more difficult to defend in a modern democracy than the relative merits of an appointed versus an elected chamber. This incrementalist approach is therefore a deliberate tactic to break the historical deadlock, secure a tangible and popular reform, and build momentum for the more contentious changes envisioned for the future. The late 1990s saw the creation of devolved legislatures in Scotland, Wales and Northern Ireland, fundamentally reshaping the UK's constitutional landscape. Under this asymmetric arrangement, the UK Parliament retains ultimate sovereignty, but by law and convention does not normally legislate on devolved matters without the consent of the relevant legislature. This principle is embodied in the Sewell Convention. The post-Brexit era has placed the settlement under severe stress, casting its legal and political limits. 3 recent developments highlight this strain. First, in a landmark 2022 ruling, the UK Supreme Court determined unanimously that the Scottish Parliament does not have the legal power to legislate for a second independence referendum without the consent of the UK Parliament. The court found that the union is a matter expressly reserved to Westminster under the Scotland Act 1998. This judgment provided a definitive legal clarification on the limits of devolved authority, closing off a unilateral route to a referendum. Second, in January 2023, the UK government deployed a powerful constitutional tool for the very first time. It uses power under Section 35 of the Scotland Act 1998 to block the Gender Recognition Reform Scotland Bill from receiving royal assent, arguing that the bill would have an adverse impact on the operation of UK-wide equality legislation. This transformed a theoretical statutory power into a concrete instrument of political conflict between the two governments.
Third, the constitutional status of the Sewell Convention has been significantly weakened. The Supreme Court, in the Miller I case concerning the triggering of Article 57, had already confirmed that the Convention is a political understanding binding in honour only and not a legally enforceable rule. In the post-Brexit period, the political force of the Convention has diminished sharply. The UK has proceeded to legislate without devolved consent on at least 6 occasions between 2018 and 2023, primarily on Brexit-related legislation such as the European Union Withdrawal Act 2018 and the UK Internal Market Act 2020. The UK government has justified these breaches by claiming they represent exceptional circumstances outside the normal operation of the Convention, a position vehemently rejected by the devolved governments.
These events collectively reveal how Brexit has acted as a catalyst for constitutional change, triggering a de facto re-centralisation of power. Before Brexit, EU law provided a common regulatory framework across the UK, naturally limiting the scope for policy divergence. Its removal created what the central government perceived as a risk of new internal trade barriers if the devolved nations enacted divergent regulations. The government's response, the UK Internal Market Act 2020, imposed principles of mutual recognition and non-discrimination that effectively constrain the regulatory autonomy of the devolved legislatures. This act, passed despite the refusal of legislative consent, exemplifies a broader trend. The political imperative to implement a UK-wide Brexit settlement has led the central government to prioritise market unity over the political conventions that have underpinned devolution for over 2 decades. This has eroded the cooperative, trust-based model of intergovernmental relations, straining the political bonds of the Union and fuelling nationalist sentiment in Scotland and Wales. While primary legislation remains the ultimate source of law, the UK's uncodified constitution is continuously shaped by other sources, particularly the interpretive role of the judiciary and the exercise of executive power. Recent statutory changes have sought to modify the tools available to the judiciary, altering the balance of power in the crucial area of judicial review. Judicial review is the legal process by which courts supervise the lawfulness of actions taken by public bodies. It is a supervisory, not an appellate, jurisdiction. Courts are concerned with the legality of the decision-making process, not the merits of the decision itself. The primary remedies available include quashing orders which nullify a decision, prohibiting orders which prevent an unlawful act, and mandatory orders which compel the performance of a duty. The Judicial Review and Courts Act 2022 introduced the most significant statutory reforms to this process in recent memory. The Act created new discretionary remedies for the courts. A court can now issue a suspended quashing order which delays the nullification of an unlawful decision to give the public body a period of time to correct its error. It can also issue a prospective-only quashing order, a more controversial power, which means that an unlawful decision is only invalidated from the date of the court's judgment, leaving its legal effects prior to that date intact. As noted previously, the Act also included an ouster clause to abolish the judicial review jurisdiction. These changes represent a deliberate attempt by the executive and Parliament to recalibrate the practical impact of judicial review. Traditionally, a successful challenge resulting in a quashing order rendered the impugned decision void ab initio, as if it had never been made. This provided a powerful and complete remedy for the claimant and a strong incentive for public bodies to act lawfully. The new remedies, particularly prospective-only orders, fundamentally alter this constitutional dynamic. By preserving the past lawfulness of an act that the court has found to be unlawful, this remedy can shield the executive from the full legal, administrative, and financial consequences of its actions. This marks a subtle but significant shift in the balance of power. It moves the focus of judicial remedies away from the complete vindication of a claimant's rights and holding the state accountable for past illegality and towards a more pragmatic model that prioritizes administrative convenience for the state. In doing so, it weakens judicial review as a tool for accountability and may diminish its deterrent effect on unlawful government action.
The protection of individual rights and civil liberties remains a cornerstone of the UK Constitution. This area has been the subject of intense political debate and significant legislative change in recent years, particularly concerning the future of the Human Rights Act and the legal framework governing the right to protest. The Human Rights Act 1998, HRA, incorporated most of the rights set out in the European Convention on Human Rights, ECHR, into UK domestic law. It allows individuals to enforce their convention rights in UK courts, rather than having to pursue a lengthy case in the European Court of Human Rights in Strasbourg. The Act operates through 2 key mechanisms. Section 3 requires courts to read and give effect to legislation in a way that is compatible with convention rights, so far as it is possible to do so, while Section 4 allows higher courts to issue a declaration of incompatibility if a provision of primary legislation cannot be read compatibly, signalling to Parliament that the law needs to be changed. For over a decade, the HRA has been the subject of political controversy, with some arguing that it has led to an unwelcome expansion of judicial power and undue influence from the ECHR. This culminated in June 2022 with the introduction of the Bill of Rights Bill by the government of Boris Johnson. The bill proposed to repeal and replace the HRA with stated aims of strengthening rights like free speech, limiting the influence of Strasbourg jurisprudence on UK courts, and making it easier to deport foreign national offenders. The bill proved highly contentious. It was widely criticised by legal bodies, human rights organisations and the devolved governments, who argued it would weaken overall rights protections, create significant legal uncertainty, undermine the rule of law and damage the UK's international standing. Following Johnson's resignation, the bill was halted by the short-lived government of Liz Truss in September 2022. Despite initial suggestions that it might be revived, the Justice Secretary formally confirmed in June 2023 that the government would not be proceeding with the bill and it was officially withdrawn. The failure of the Bill of Rights Bill demonstrates the remarkable resilience of the Human Rights Act. It survived as not the result of a newfound political consensus in its favour, but rather the consequence of the profound legal, political and constitutional difficulties involved in its repeal. The proposed alternative was seen by a wide range of stakeholders as unworkable and regressive, and it failed to command the political support it needed to overcome this powerful opposition. The status quo has therefore endured, not through enthusiastic endorsement, but by default, as the complexity of unravelling the 1998 settlement proved a greater obstacle than its critics had anticipated. The right to freedom of assembly is a fundamental civil liberty, protected by the common law and Article 11 of the ECHR. The traditional legal framework, primarily based on the Public Order Act 1986, sought to balance this right with the need to maintain public order. However, this area of law has been radically transformed by two recent far-reaching statutes passed in direct response to the disruptive protest tactics employed by environmental groups such as Extinction Rebellion and Just Stop Oil. The Police Crime Sentencing and Courts Act 2022 and the Public Order Act 2023 have together created a new and more restrictive legal framework for protests. The PCSC Act lowered the threshold for police to impose conditions on marches and assemblies, including those conducted by a single person. Crucially, police can now impose conditions based on the noise generated by a protest if they reasonably believe it may result in serious disruption to an organisation or have a significant impact on people in the vicinity. The Act also created a new statutory offence of public nuisance and made it easier to convict protesters for breaching conditions by lowering the mental element of the offence to whether they knew or ought to have known a condition was in place.
The Public Order Act 2023 went further, introducing a suite of new criminal offences targeting specific protest tactics. These include offences of locking on, attaching oneself to objects or people, being equipped for locking on, interfering with key national infrastructure such as airports, railways and printing presses, and obstructing major transport works. This act also granted the police new powers to stop and search individuals without suspicion in a designated area if they believe protest-related offences may occur. The cumulative impact of this new legislation represents a fundamental paradigm shift in the policing of protest in the UK. The legal framework has moved decisively from a model focused on facilitating peaceful protest while managing disorder to one centred on preventing disruption. The creation of preparatory offences, such as being equipped for locking on, and the introduction of suspicionless stop and search powers shift the focus of policing from managing an event to preempting it. The ambiguity of key trigger concepts like serious disruption and significant impact, the interpretation of which is left to the reasonable belief of a senior police officer, grants the police wide discretion and creates significant uncertainty for protesters. This uncertainty risks creating a chilling effect, deterring individuals from participating in legitimate and peaceful demonstrations for fear of inadvertently falling foul of these broad and vaguely defined new laws, thereby altering the constitutional balance between freedom of assembly and public order that has prevailed for decades. The analysis presented in this podcast confirms that the British Constitution, while maintaining its core formal structures, is undergoing a period of profound and rapid substantive change. The foundational principles and institutional arrangements described in the introductory material remain the starting point for any discussion, but they are being actively reshaped by contemporary political pressures. The twin forces of implementing Brexit and managing the subsequent strains on the domestic union have catalysed a powerful reassertion of parliamentary sovereignty in its most absolute executive-dominated form. This has been manifested in the legislative dismantling of the EU legal order via the REEUL Act 2023, a process that has concentrated vast lawmaking power in the hands of ministers. This centralising impulse has also recalibrated the UK's territorial constitution, with the political conventions underpinning devolution giving way to the legal supremacy of the UK Parliament when deemed necessary by the central government. This assertion of political and executive power has been accompanied by a legislative pushback against the judiciary, evident in the Judicial Review and Courts Act 2022, which has both curtailed the court's jurisdiction and modified their remedial powers to the benefit of the executive. In the realm of civil liberties, a similar trend is visible in the new public order legislation, which has fundamentally altered the legal balance in favour of preventing disruption over facilitating protest. The traditional image of a constitution evolving slowly and organically through convention and consensus is being replaced by a new reality of rapid, contested change driven by statute, reflecting the deep political and constitutional fissures of the current era. If you enjoyed this podcast, give it the thumbs up and have a look around Dr. Yannis' channel for more.